Hello, I'm Aiden Durham, attorney with 180 Law Co. in Colorado. You're watching All Up in Your Business, where today we're gonna go through your comments and answer your legal questions. Before we do all of that though, remember that I am a lawyer, but I am not your lawyer. So even though I'm answering some legal questions in this video, all the stuff that I talk about here is not a substitute for actual legal advice. If you need help with any legal situation, you should consult with a lawyer. All right, let's dive right in. Can you suggest any trademark services? I sure can. I think my own trademark services are top-notch, really, just the best there is. I have a few different options and packages for my trademark registration services. Some to fit different people's circumstances and needs and budgets and all of that. I will link to some of that info down in the description so you can learn more and get in touch with me if you're interested in working with me to get your trademarks registered. My question is, what's the weirdest trademark application you have been a part of or you have heard of? The weirdest that I've been a part of, not necessarily the application was weird, but more the process. My client's trademark application was being opposed, I think. Another party was challenging the validity of their registration. Didn't want my client's trademark to get registered. Someone else was challenging it. And we had some back and forth with the other party about who had rights, who had priority to this trademark. And it came to light eventually that the other party was faking documents. They sent some documents to an IT person and had them fake, Photoshop on some dates on these documents to make it look like they had been using the trademark earlier than they actually had. So totally fraudulent. You can't do that. Us as lawyers, if we are aware of these kinds of things, we are prohibited really from continuing to assist our client in perpetuating these lies or this fraud, and we have the ability in that instance to withdraw or get out of representation. That's what the other attorney did in this case. They notified me and my co-counsel of what was going on, and they withdrew, and basically the problem solved itself because the other party was lying and faking things. Aside from that, the weirdest application that I've heard of, I was not a part of this. Make that very clear. I had nothing to do with this. I just came across it while I was doing a search one day. And I don't know if weird is the word that I would use for it, but there was a pending application for Clan Cosmetics, both words starting with a K, Clan Cosmetics. I don't know where the applicant was going with that or what their intention was, but that's a choice. That's a choice that this applicant made. The application was abandoned for reasons I don't know. I didn't look too much into it, but I thought that one was odd. Your biggest fan, thank you. Question, I have a registered trademark. If I want to add an additional good class like clothing to my existing classes, is there an amendment or do I have to fill out the entire application again? Yes, you can't amend a registration to add goods or services. Once it's registered, and really once you've submitted the application, you can't make any changes to the goods or services that might broaden or add things. We can narrow and we can get more specific, but we can't add. So if you add a new product line or expand your product line, start selling clothes, the only way to add that to your registration is to reapply and go through the whole process again. To file for international trademark, which one do I use? WIPO, that is an option. It depends on the country, the jurisdictions that you're looking to register in. There isn't really a blanket option for getting an international trademark. So I can't really answer that. It's specific of what other jurisdictions you're looking to register in. Is it a breach of contract for a creditor's governing law to state Delaware and then for the same creditor to begin using another state's laws in their lawsuit? So contracts typically will have a governing law provision that says if there is a dispute in the enforcement of this contract or something like that, then the laws of state X will govern. In this case, Delaware. To be using another state's laws in their lawsuit. I don't understand exactly what that means. Just because there's governing law in the contract doesn't mean that either party is prohibited from using laws, not necessarily the laws, but the legal precedent of other jurisdiction in their arguments. Governing law, for the most part, applies just to the contract itself. Which state's laws are we going to look at when it comes to enforceability of this contract or interpretation of the contract? Not necessarily in applying the law to the issue at hand. I'm doing a poor job at explaining this. The answer, though, is no. In any event, it wouldn't really be breach of contract anyway. It would be some other procedural thing that might prohibit them from using a different state's laws in their lawsuit. But if I understand your question correctly, I'm going to go ahead and say no. That's not breach of contract. I'm uploading a documentary on the El Reno tornado. I've changed the color saturation, added subtitles and a couple of my own comments, added an intro and outro and a border frame. Is that fair use? I can't say for sure. There's no hard line rule, black and white rule when it comes to fair use. Safe bet, based on what you've told me, I'm gonna go ahead and say no. That probably wouldn't be considered fair use. You have to make some kind of transformative use of the work. A couple of my own comments. The one thing that could maybe work in your favor here might be the adding your own commentary to it. If you're commenting on a work, that helps you in demonstrating fair use, but a couple of my own comments, probably not. The color saturation, the subtitles, the intro and outro, that's not really transformative. That's not really changing the work. Maybe it is, but my best guess based off what you told me, probably not. I wouldn't guess that that's fair use, no. Question about the classification of trademarks. I want to trademark my birth name. I know it can be done. My question is, what classification would I put it under? Correct that you can get a trademark registration for your birth name. What classification, what class of goods and services would you put it under? Depends on what you're going to use it for. You can't just get a trademark for your name, then that's it. You have to use it as a trademark, meaning you use it in connection with the offering of some good or service, and that would lead you to the correct class that you would put the registration under. So if you are using your name, let's say with a cosmetics line, you would choose the class for makeup cosmetics. If you're going to use your name on clothing, then you would use class 25, which applies to clothing and apparel items. If you were going to do like coaching, business coaching, or personal coaching services, I think that's 35. 41, that's educational. 41 is entertainment and education. Anyway, it depends on what you're going to use the name with. It depends. You have to decide what you're going to use your trademark in connection with, and then that will tell you what class or classes you should use on the registration. Hi, so you're saying that even if someone trademarks my business name with a different logo, I could still use my business name with a different logo as long as it doesn't look the same? No, that's not what I'm saying. I don't know exactly what video where you're getting that from. That's not specifically what I'm saying. It all depends. Different logo, just different logo, same name, that's not enough to make to give you an answer. When we're talking trademarks and trademark infringement and likelihood of confusion, a bunch of different factors go into it. Some of those are how the trademark appears, the visual, how it looks, how it sounds spoken aloud, the meaning, the connotation, the commercial impression, also the goods or services with which the trademark is used. So if there are two companies that have identical names, completely different logos, if they're in the exact same industry, it doesn't matter that the logos look different because the goods and services are going to be the same, I assume, and the names are the same. The fact that the logo looks different probably isn't going to matter. If the goods or services are completely unrelated, the names are the same, but the logos are different, that's probably okay. A go-to example that we like to use is Delta Airline and Delta Faucets. Same name, I assume different logos. I haven't looked them up, but I assume different logos, but completely different things. One's an airline, one sells faucets. So all these different factors matter. So just changing the logo isn't necessarily going to be enough, but if the goods and services are completely unrelated, then yeah, someone with the same name and a different logo could coexist with your business that has the same name and a different logo. I am looking to sell rock-like decorations that are to be placed inside of an aquarium. Can I be sued if someone were to cut their fingers on the sharp, rough surface of these rock decorations? What can I do to protect myself from a lawsuit like this? I included someone else's response to this because it's pretty spot on. People sue for some of the craziest things. You're right, they could cut their finger, drop it on their toe, or they could claim that your product killed all their fish. Insurance would be a good idea. That was gonna be my answer. Could you be sued? Yeah, people sue for all sorts of reasons. If there's some kind of problem with the product, some issue that causes it to be more dangerous, that is a situation where you could be liable for it. Even if that's not the case though, people could still sue you. That doesn't necessarily mean they're going to be successful and win, but someone could still sue you if they're injured from your product. Absolutely. And what can I do to protect myself from a lawsuit like this? Insurance is going to be your first line of defense. Product liability insurance most likely would be applicable here. If I already used my home address and would like to now get a virtual address, how do I change my business address? I'm assuming this is in the context of I used my home address on my LLC documents to form my LLC or something. You can file a document with the state to change your business address. Exactly what document that is, it depends on the state. In Colorado, we would file a statement of change, changing the principal office address. We could also update the address on the periodic report on the annual filing. I believe most states that have, some kind of an annual or regular filing requirement, that's a good opportunity to change the business address if you need to. Otherwise, look for some kind of an amendment document or some kind of address change document that can be filed with the state. So the same department, same agency that you filed to form the LLC or the company, they should most likely have a form that allows you to change the address of the company as well. Can you register a trademark prior to when you start using it, conducting business? In other words, can the date of first use be a future date? What date should you use if you don't have an exact future date? No, no, and no. You cannot register a trademark before you start using it, before you start conducting business. The date of first use cannot be a future date, and what date should you use? You should use the date of first use. You can start the process before you've started using the trademark in commerce. You can submit the application, you can get the ball rolling, you can start the process, but it won't be registered until you've started using it in commerce. And the date of first use would be the date that you started using it in commerce. So you wouldn't need to put a future first date. You would use you would file on a 1B intent to use basis, in which case the application doesn't require that you put a date of first use. You would submit that later when you file a statement of use once you've started using the trademark. I haven't said this in a while. I'm going to bring it back. I feel it's very applicable here. A trademark isn't a trademark until it becomes a trademark. The thing is just a thing before you've started using it, before you've started conducting business. It's not a trademark yet. Your business name, it's just a name, it's just a word before you started using it in your business. Once you've started using it in commerce, now it's a trademark. So no, the answer is no. You have to be actually using it in commerce before it will get registered. All right, That's all for this round, you guys. Thanks so much. Had a great time. Check the description if you want info about my trademark services. I will also link to my free trademark guide that you can download. Down there, you can check out my DIY trademark course if you are interested in doing this trademark thing by yourself. If you can't or don't want to work with a lawyer, that's up to you. All that info will be there down in the description. Thank you so much for watching. I'm Aiden Durham, and I'll see you next time.